Thank you for joining us for today's webinar. So before I introduce our presenter, I just want to mention our internal sponsor, the business consulting team at Farm Credit East. We've got a great staff that provides a number of services, including profitability consulting, estate and succession planning, and help customers with a wide range of business management issues, including those related to labor and workforce. So please contact your local Farm Credit East office to get in touch with our business consultants to see how they can help you with your business. So turning to today's topic, ag labor and immigration policy. They've both been hot topics this past year. Just 2 weeks ago, the U.S. Senate took up immigration policy as it tried to address the DACA issue. Interestingly, none of the Senate bills that were considered, and ultimately none of them passed, none of them addressed ag labor concerns. On the House side, Judiciary Chairman Bob Goodlatte has a comprehensive immigration bill that he may try to advance. That does include some specific ag provisions for a new ag guest worker program, though the prospects for that going forward are uncertain. But those are the things that are being talked about going forward. Today, we're really going to focus on what's in place now, and that is the H2A visa program. It's an important program to many ag employers in terms of helping them provide for their seasonal workforce needs. And so we want to take a deep dive into how to navigate that process because it can be a fairly complex one. Leonard J Dirigo, or LJ Dirigo, from the law firm of Whiteman Osterman Hanna in Albany, New York. LJ specializes in the area of immigration law. He's an expert on a wide range of issues in this practice, certainly and especially as it relates to agriculture, including the handling of H2A as well as the H2B visa program. He's the immediate past chair of the upstate New York chapter of the Immigration Lawyers Association, and he holds an undergraduate degree from the University of Albany and has his Juris Doctor from Albany Law School. And with that, I'm going to turn it over to LJ for the presentation.
Thank you, and welcome everyone this morning. So one of the most pressing issues facing the ag community is really labor. How do we secure reliable farm labor to fulfill seasonal needs? Advertising doesn't seem to work, and if you're lucky enough to hire a U.S. worker, they may not stay more than a few days. So in this webinar, we're going to navigate through the complex maze of the H2A agricultural visa program, and I want to provide an overview of visa requirements, procedures, compliance, and employer obligations under the program. We're also going to discuss some strategies for achieving year-round coverage for farm workers and joint employer filings for multiple farms. So H2A is an extremely complex process, and there are a lot of subcategories within that and requirements. So we're going to give more of a high-level general overview of the program because of the complexity. We can honestly spend 2 days just talking about H2A. So we're going to kind of give a general, more broad overview. All right, so as I just mentioned, the need for reliable supply of seasonal workers is just not being met. And I think a lot of this is because the U.S. government tends to be conflicted about the availability of U.S. workers. I think people look at high unemployment rates in certain areas and they assume that there's plenty of people out of work that would love to take these jobs. But in reality, there's a disconnect there, and that's not always true. There's been a patchwork of prior programs, here and there, but nothing that's really led to a long-term viable solution. So the H2A program serves about 7,700 agricultural employers, and I did update this number, and it does fill over 140,000 jobs out of all farming positions. There's an estimated more than half of 1.2 million farming positions are filled by illegal workers. So you can see that this is an issue that's greatly affecting the ag community. So what does the seasonal temporary business do to get the workers it needs? Before we go into the H2A program, I want to talk a little bit about the problem of illegality. Why is it such a big deal for people that are here illegally, and what are the consequences? Well, the basic rule in our immigration system is that no visa problem can be fixed from within the U.S. So if there's an immigrant that has violated their visa status, whether that means overstaying a visa that they entered on, or engaging in illegal employment, or simply crossing the border illegally, the problem can only be fixed by the alien leaving the U.S., to fix their problem in their home country at the U.S. consulate. So we have a very strict policy here in the U.S. We're not going to make it easy, and we're not going to reward anybody that's here illegally when they bypass our immigration system. Sometimes re-entry is enough to cure that deficiency. Other times they're going to have to apply for a new visa at the consulate in their home country. They can amend, change, extend, or file any type of visa application in the U.S. when they're out of status. There's a concept in our immigration law that really we enacted in 1996 as part of a large-scale immigration reform program, and that's something called the 3- and 10-year bar, which basically prevents people that are here illegally from ever going home. It results in permanent illegality, and what that law says is that there's anybody in the U.S. that's here illegally and they're here for 6 months illegally, then we're going to ban them from coming back into the U.S. for 3 years if they leave. So if there's somebody that's in the U.S. illegally for a year or more, when they leave the U.S., they automatically trigger a 10-year bar, preventing them from coming back into the U.S. for 10 years. So you can't fix the visa status in the U.S., but they can't leave because then they'd be barred from coming back. So what we see happening is there's really not much of an incentive for anybody to go home that's been here over 6 months illegally. So that does greatly contribute to our illegal immigration problem. And as we talk about policy options in the immigration debate, one of the considerations would be, well, what if for at least a temporary period of time, we abolish this 3- and 10-year bar? We just get rid of that for a little bit of time. I think it'll be interesting to see how many illegal individuals are in the U.S. that would essentially self-deport and leave. They've got families back home that they haven't seen in years, but knowing that they won't be punished from coming back in the legal way, that's an interesting thought. And I think that issue may come up in the immigration debate. So conclusion, you can't fix the status of any worker that is illegal. So it's probably not a good expenditure of your time to try to fix something because the rules are very strict. Nothing can be done within the U.S. All right, so who qualifies for the H2A classification? Well, the H2A agricultural program allows ag employers who anticipate a shortage of U.S. workers to bring non-immigrant foreign workers to the U.S. to perform agricultural labor or services that can be demonstrated as temporary or seasonal. So employment is considered seasonal if it's tied to a certain time of a year by an event or pattern, such as a short annual growing cycle. So usually we link this to a crop season. And then it requires labor levels above what's necessary for ongoing operations. So employment is considered temporary when the employer's need for the position with a temporary worker, well, except in extraordinary circumstances, lasts no longer than 1 year. And Department of Labor sort of applies a rule where it can't be more than 10 months. But the employer needs to demonstrate to qualify for H2A that they really are not sufficient, able, willing, or qualified U.S. workers available to perform this position. The other part of this is the employment of H2A workers can't adversely affect the wages and working conditions of other farm workers employed that are U.S. workers filling that role. So who's considered an employer under the H2A program? Well, an employer must qualify as a U.S. employer, and usually that's defined as a farm or ranch, an association of agricultural producers, or a farm labor contractor. All of these entities are able to sponsor an H2A program. Associations of agricultural producers can also participate as a sole member, as an agent with one member, or as a joint employer with multiple members. The work must consist of agricultural labor or services such as planting, raising, cultivating, harvesting, or production of any agricultural or horticultural commodity. We'll talk a little bit more about that exact definition about what work qualifies in a few minutes. The work must also be full-time, so which means 35 hours or more per week under the H2A program. And the employer's need for workers must truly be seasonal or temporary, again, lasting no more than 10 months. So this slide is basically a very brief snapshot of the H2A program. We have and we'll talk about the actual requirements in much more detail. But again, the job has to be for agricultural labor or services. The job must be temporary or seasonal. The employer must recruit pursuant to Department of Labor instruction and maintain a recruitment report that hires U.S. workers up to 50% of the contract period on the H2A. Worker housing must meet Department of Labor or Department of Health standards. And there's a prevailing wage or adverse effect wage requirement for the H2A program. For New York, it's currently set at $12.83 an hour. Application steps, we first start out with the New York State Department of Labor. And for timing, it's 60 to 75 days prior to your need date is where we start that initial stage with the New York State Department of Labor, followed by filing with the U.S. Department of Labor located in Chicago. Department of Labor then issues instructions on advertising where the advertising has to run in an effort to recruit U.S. workers. After Department of Labor completes processing, U.S. Citizenship and Immigration comes into play, and there's a petition filed with that agency. And finally, the U.S. consulate in the worker's home country is the agency that issues the actual visa in their passports for them to enter the U.S. The cost for the Department of Labor stage, there's a filing fee of $100, a flat fee, and then an additional $10 per worker. U.S. Citizenship and Immigration filing fee is $460, and then consular fees can range up to between $100 and $300 per worker. All right, so some H2A considerations. So again, going back to that definition of agricultural labor, USCIS and Department of Labor basically use the IRS definition of what ag labor is. And so basically the regulations provide that agricultural labor includes services performed on a farm by an employee of any person in connection with any of the following activities: cultivation of soil, raising, shearing, feeding, caring for, training, or management of livestock, bees, poultry, and fur-bearing animals or wildlife, or the raising or harvesting of any other agricultural or horticultural commodity. So that third prong is really where most farms will fall into in terms of crop-related work. The definition has changed over time. In the past, Department of Labor had softened its interpretation of ag labor and also included something called incidental duties. So if an actual duty wasn't listed on your H2A application, it was okay if it was incidental to the duties listed. And a lot of times, dairy farms would use that as a way, if you file under a crop to have incidental duties related to going into the milking parlor and performing maintenance work in that capacity as well. The distinction between ag work and non-ag work is important because that basically dictates what visa category you would fall under. So H2A is strictly ag. Non-ag, temporary or seasonal labor would fall under the H2B program, which is very different and have different requirements. So H2A visas, the best thing about them, I would say, compared to the other visa programs, is that they're not subject to an annual cap. They're unlimited, whereas the H2B visa is limited to 66,000 visas per year. And just to let you know how in demand the H2B visa is, on the very first day of filing for the April 1st season on January 1st, the government received applications covering 170,000 workers for 33,000 slots. So that visa category is very highly oversubscribed. So H2A is a big benefit because there is no limit like that, and you can really apply every year without worrying that there's going to be a limit on visas. The H2A does impose requirements for on-site inspections of housing, provision of meals and living facilities, and we're going to talk about that in a minute. The H2A workers get paid transportation as well in both directions. So you have to reimburse workers for transportation to the U.S. and then back home at the end. We're seeing the H2B program is following suit with some of these requirements, and they're making that program more and more like the H2A. So You know, for a long time, a lot of people said, oh, we're going to try to do H2B instead because there are fewer requirements. Well, it's moving in the direction of H2A in connection with the same advertising requirements, transportation requirements, and things like that. So the H2A wage requirements. So as an H2A employer, you have to offer, advertise in recruitment, and pay workers the highest of the following: the adverse effect wage rate, and that's a rate set per state. So for New York, for 2018, that wage rate is $12.83 an hour, or the prevailing hourly wage rate or piece rate, or collective bargaining wage, or federal or state minimum wage, whichever is the higher of all of those wage requirements. Also, one of the what we've been seeing as a recent trend in H2A Department of Labor audits is discretionary bonuses or paying workers a higher rate than what you were offering in the advertising or application. So you have to disclose any differentiation in wages, or if you're paying them a bonus, you have to mention that in the advertising and in the H2A job order. And the language that we recommend using is raises and or bonuses may be offered to any worker in a specified occupation at the company's sole discretion based on individual factors, including work performance, skill, or tenure. And that way you're putting on notice out there that there's the possibility in certain circumstances where the wage rate may be different. So the H2A certification process. So again, stage one starts with the New York State Department of Labor, also referred to as SWA, State Workforce Agency. So the employer submits Form ETA 790, which is a job order clearance form, with the State Department of Labor, and notifies the state of its intent to file a future application for H2A workers with the U.S. Department of Labor. The job order has very specific language that needs to go in it, and it has to meet minimum requirements set forth in federal regulations. And we're going to talk about what those requirements are. The State Workforce Agency reviews the job order and notifies the employer of any deficiencies within 7 days, or if it's acceptable, they begin the recruitment of U.S. workers within the state of New York through the intra-clearance system. The employer will typically request that the state inspect the housing for farm workers during this initial stage. And usually what we see is right after you file the ETA 790 with the New York State Department of Labor, they will initiate or contact the employer to schedule a housing inspection. So the job order content. So these are also requirements and the regulations for participating in the H2A program. So all of these need to be listed in your job order. They don't have to be listed in the newspaper advertising, but the job order needs to contain the fact that the employer will provide housing to workers who can't return to their home at the end of the workday, provision of workers' compensation coverage, provision of tools, supplies, and equipment needed to perform the job. You can't charge employees for these tools or have them provide their own tools. You have to provide meals or cooking facilities, provision of transportation and daily subsistence expenses during the time that they're traveling to the U.S. You have to guarantee them 3/4 of work for the contract period. So that's a guarantee that you need to make them, or you have to pay out the remaining if something happens and you can't employ them for the full 3/4 period. Hours, earnings record, rates and frequency of pay need to be provided. Abandonment or termination for cause, contract impossibility. So you need to define that in the application. Any required deductions from workers' pay need to be noted. And then the work contract or the ETA 790 and attachments, those need to be provided to the workers by the time that they start work. So housing, as an H2A employer, you're required to provide housing to your workers. The housing must be ready for occupancy 30 days prior to date of need. So in the event that you have a housing inspection as part of the initial filing, they will likely give you a checklist if there's deficiencies of things that you need to fix. The U.S. Department of Labor will not approve your application until the housing inspection is complete and it meets the requirements. The housing requires inspection by either the State Workforce Agency, which is the New York State Department of Labor, or the Department of Health, depending on how many workers you have. Rental or public housing may be acceptable. That would also require inspection by either the Department of Labor or Department of Health. So what determines whether or who actually does the inspection, whether it's your county Department of Health or the state Department of Labor? If you have housing for 5 or more workers, that requires a Department of Health inspection. If you have fewer than 5 workers in the housing, then the state Department of Labor will just come out and do the inspection. And the U.S. Department of Labor has on their website frequently asked questions on H2A, and they did address all of the housing issues in FAQ round 12, which is available on their website. So stage 2 is filing with the U.S. Department of Labor. So the employer submits the following documents through an online filing portal called iCert. So this is an employer would register, or your agent, if they're doing it for you, would register an account on the U.S. Department of Labor website for you to submit applications. So there's a form called an ETA 9142, which is an application form that's completed online and submitted to Department of Labor. There's also an Appendix A form, which basically the employer and the agent signs off on, confirming that it's going to comply with all of the obligations under the H2A program. And then you're going to submit a copy of the job order, or the ETA 790 form that you had filed with the State Department of Labor. The State Department of Labor sends you basically a stamped or certified copy of that, which you're going to have to upload into the system with your U.S. Department of Labor filing. If there's going to be multiple work sites, you need to identify each work site that the workers will be at. As part of that application, you have to upload proof of workers' compensation coverage that covers the entire period of need that you're requesting. And then the State Department of Labor or Department of Health will automatically send the housing inspection report to the U.S. Department of Labor. So that's something you don't have to provide directly. You also have to have upload any agent agreements showing that you have given authority to an agent or attorney to act on your behalf, as well as a letter confirming whether or not you're using a foreign recruiter to bring in workers. And if you are using a foreign recruiter, Department of Labor will require a copy of the contract that you have with that recruiter, confirming that the workers are not responsible for paying the agent directly. All costs with this H2A program are an employer expense, and you're not allowed to pass anything on to the workers. Now, this would come up in connection with an audit later on for a prior season. So you want to make sure that you have proof that you paid for reimbursement, you paid for the agent costs, and that nothing was passed on to the workers. All right, so after you file your ETA 9142 with U.S. Department of Labor, within 7 days, something's going to happen. So within 7 days, the Department of Labor is going to review your application for any errors or inaccuracies and for compliance with program requirements. Now, don't freak out when you get this, because I will tell you that it happens all the time and it's very routine. It's very rare that you're going to file an application and have a perfect application with no deficiencies, because they will nitpick each and every element of your application. So it's very common to get a notice of deficiency, and in most cases you can simply cure that by submitting a response by email or clarifying a certain element in that application. So if everything's okay and after you respond to a notice of deficiency, then they will issue a notice of acceptance. So the notice of acceptance is where the Department of Labor says everything is in order, everything looks good on your application, we're now allowing you to start your recruitment phase. So they're going to tell you where you need to place advertisements, and it'll be essentially your local newspaper on a Sunday newspaper, and then one weekday. And then in addition, they're going to tell you 2 or 3 other states that you need to advertise in to do positive recruitment. And those ads, can be online ads, and we'll talk about that in a minute. And after, and I want to mention too that if you do get a notice of deficiency, you have 5 days to respond to that. And if you don't, there's a good chance that Department of Labor will deny the application, and then you'd have to start over again. So the initial recruitment report. So as part of the recruitment process, so after your newspaper ads are done and you're going to be getting referrals from Department of Labor, you may be getting contacted directly from applicants. You really need to interview each applicant and at least conduct a phone interview with them to determine whether they meet the requirements of the position. For H2A, there's not a whole lot of ground to disqualify a U.S. worker. There's very limited experience that you can require for a farm worker position, for example. You may be able to get away with requiring 1 month or maybe up to 3 months experience, depending on whether they coded as an agriculture equipment operator or a farm worker. But if there's no experience requirement, then you have really no grounds to disqualify a U.S. worker. Department of Labor will expect you to hire that U.S. worker, even if they have no farming experience. So at the end of the recruitment, you as the employer will prepare, sign, date, and submit a written recruitment report on a date specified by the certifying officer in that notice of acceptance. The recruitment report has to contain very specific information as required by Department of Labor. You have to name the recruitment source by its name, as well as the dates that the ads ran, the name, contact information of any U.S. worker who applied, and then the disposition of each worker. So in that case, you can say, well, maybe they initially contacted you, but they never followed through with the interview or called back, or didn't provide the information that you requested. So you need to just say whether or not that worker was hired or whether they were not hired and why they weren't. You need to confirm that former U.S. employees were contacted and by what means to be invited to come back for the season. An explanation of the lawful job-related reasons for not hiring each U.S. worker. So all of that needs to be documented in your recruitment report. Again, if there's no lawful basis for disqualifying a U.S. worker, Department of Labor expects you to hire that person. And what they will do is they will deduct one requested H2A worker for each qualified U.S. worker that they find. So if you're requesting 6 H2A workers, well, if you've got 2 U.S. citizens that applied that you have no basis for disqualifying, then you may end up getting a certification for 4 workers. All right, so the H2A notice of acceptance, a little bit more about the recruitment. So the notice of acceptance directs the employer to place the advertising. So you need to place 2 advertisements in your local newspaper, 1 Sunday and 1 weekday print edition. Again, contact former U.S. employees, conduct out-of-state recruitment. So usually Department of Labor lists 2 other states, and usually I see New Jersey and Pennsylvania, sometimes Puerto Rico, for you to advertise in, because the way that Department of Labor views this is that if you're willing to bring in workers from outside the U.S., you're certainly willing to bring them in from another state. So they usually pick 2 states that have high unemployment rates, and then you need to advertise in those states. So, and there can be additional recruitment that can be ordered at the discretion of the certifying officer at any time. The positive recruitment, which is the recruitment in the other states, must occur no later than 3 days before the start date of work. Report of recruitment efforts can be submitted by the date specified in the notice of acceptance, even if the ads have not all run. You basically just include what's been done to date and then the dates where the ads may run at a later time. So the issuance of the labor certification. So the temporary labor certification will be granted no later than 30 days before the start date of work. That's in the immigration regulations. The employer has the right to appeal any denial by Department of Labor for its certification request. Department of Labor will issue an original form ETA 9142 that's certified on blue security paper to the employer. That's your formal approval from Department of Labor. At that point, then you're going to submit that original ETA 9142 to U.S. Citizenship and Immigration Services as part of the 3rd stage of filing. So a little bit more about the Department of Labor's final determination. Again, DOL issues a final determination 30 days and sometimes even earlier before the start date of work, as long as all the program requirements are met. Some of the common reasons for certification being delayed is that the employer does not provide proof of workers' compensation coverage, showing coverage for the full period of the dates that you're requesting. Maybe the housing documentation isn't submitted for farm workers. If you're using a labor contractor, the license hasn't been submitted. Valid surety bonds for labor contractors, or maybe you just didn't submit the recruitment report, or there were deficiencies with the recruitment report. Department of Labor will generally provide you with additional time to cure any deficiencies to obtain the certification. So they usually don't issue a straight up denial. If you're missing information, they will always give you the opportunity to cure it. And again, that can even be done by email or uploading documents through the Department of Labor's online system. Some pre-certification amendments are possible. So if you feel like something's changed and you don't need as many workers as you need, or maybe you need more workers, you can make those changes prior to final approval by Department of Labor. You have some flexibility with also changing the dates. You just can't make any changes after Department of Labor issues the formal approval or certification. Just some general filing tips at the Department of Labor stage. So post-certification recruitment obligation. So just because Department of Labor approves your application doesn't mean you're done with recruitment. You have to continue to cooperate with the New York State Department of Labor in recruiting for the job opportunity and provide employment to any qualified U.S. worker that applies for the job up to 50% of the contract period. So once your dates of need reach 50%, then the recruitment obligation ends. But you do need to continue to interview and hire U.S. workers that apply. You have to continue to update your recruitment report after the initial one submitted to Department of Labor throughout the entire recruitment period, up to 50% of the contract period. You have to sign and date a final written recruitment report and keep that in your file. That does not have to be submitted to Department of Labor unless they specifically ask for it later or when they request it in connection with an audit later on. Some general reminders: you have to pay the required H2A certification fees in full within 30 days after Department of Labor approves your application. So again, those filing fees are a flat fee of $100 and then $10 per worker. So they will send you an invoice along with that final certification. Just be sure to pay that in a timely manner. You have to maintain all of your H2A documents that support the certification for a period of 3 years. Department of Labor, when they do an audit, they can ask for 3 years worth of advertising and other documentation, including resumes, recruitment reports for people that applied. You also have to report the termination or separation or abandonment of your workers in a timely manner. So no later than 2 working days after the departure, you have to report them to USCIS and Department of Labor. So in a no-show context, so if a worker doesn't show up for 5 work days, then you have to, then the 2-day requirement kicks in. Within 2 days of that, you have to notify Department of Labor and USCIS. If changing period of employment requested, you have to ensure that changes represent a bona fide business need. Claiming expected government delays is not an acceptable justification for changing dates. So after Department of Labor is done with their processing, then it moves on to filing with U.S. Citizenship and Immigration, formerly known as INS. So the petition context is an application form or several application forms that are completed. There's an employer support letter, so a letter from the employer confirming the need, the job description, and a little bit of background about your farm. You're including the original labor certificate that was received by Department of Labor. There's a filing fee of $460. These petitions are submitted to the California Service Center for H2A. You can include both named and unnamed workers on one petition. So what we see generally is sometimes you already know the workers that you're bringing in and you bring the same ones in every year. So you have an option of either naming them on the petition paperwork or just doing it for unnamed workers. My practice is usually just to include, however number of workers you want. If you need 10 workers, just do 10 unnamed workers and not name any particular worker on the petition. That way, that gives you flexibility at the consulate. If one of the workers can't come for some reason, you can substitute other workers in there. There's no special filing fee for premium processing like there is for the H2B category. USCIS automatically expedites H2A, and you could have an approval usually in 1 to 2 weeks. So the final stage is consular processing. So in this stage, after USCIS has approved the underlying H2A petition, then you can use a recruiter outside the U.S. or you can do it yourself, but you basically request an appointment with the U.S. consulate in the worker's home country, whether that be Mexico, Guatemala. We actually use some very good agents there that actually recruit for us and also schedule the interviews online. You can substitute workers at the consulate if necessary. Each worker will complete an application form online, the DS-160 form. Again, the agent usually helps the workers prepare that. There's a $190 application fee that's paid in advance at a designated bank in that country. Some of the documents that are submitted would be the worker's passport, that DS-160 form, the approval notice issued from U.S. Citizenship and Immigration granting the employer for the H2A classification, and the receipt for the fee payment. So if the workers have family members, sometimes it works, sometimes it doesn't. They're technically eligible for something called an H4 visa, which will allow family to accompany the worker in the U.S., but many consulates have a policy where they won't allow family members to get a visa to come with the worker simply because they're afraid that if their family comes, they're going to overstay that visa. Whereas if they have family members remaining in their home country, that sort of serves as collateral for them to go back. So that's why they basically hold the family members hostage in an effort to approve the visa for the H2A worker. So just to go over some of your obligations as an employer for H2A workers, again, we talked about this before, but providing free housing, you need to pay inbound transportation and subsistence expenses and outbound transportation to your workers to and from the U.S., guaranteeing work for 3/4 of the contract period. You provide 3 meals a day or kitchen facilities, workers' comp, provide them with a work contract or a copy of the ETA 790 form that was filed so they know what the position entails and what the required benefits are under that. Again, pay them the $12.93 adverse effect wage rate or the higher of the other categories. So tax and withholding requirements. So taxation of H2A workers has been a very thorny subject over the years, and part of that is because there were conflicting interpretations by IRS and Department of Labor. And finally, the IRS did come out with guidance on how to treat H2A workers for taxation, and they now have a whole web page devoted to that. But just, without getting too far into taxation requirements, the Fair Labor Standards Act wage requirements are not applicable to H2A workers, so therefore no overtime pay is required over the 40 hours. The employer does not withhold Social Security or Medicare withholding for H2A workers, only U.S. citizens that would be performing H2A caliber work. And this is because payments to H2A workers are not technically considered income under IRS regulations. One of the newer things that they added was voluntary federal income tax withholding. So at one time, the IRS said that the 1099 form was the appropriate way to report wages to your H2A workers. Well, they changed that, and now the rule is that you need to report wages on the W-2 form and not a 1099. You don't have to withhold income taxes, whether state or federal, unless the worker voluntarily authorizes it. My position has always been that it's safer to withhold taxes because the workers could actually end up with a tax liability that they're not prepared to pay. So by withholding, that protects them from having to make a tax payment at the end of the year. Otherwise, they can get a refund if they overpaid. But in order to do that, the worker has to agree. And my recommendation is always to get it in writing, get authorization in writing from the employee if that's what you decide to do. And they should be, you should explain to them the consequences, the pros and cons of both ways, and warn them that there could be a tax consequence at the end of the season if they trigger tax liability. Other H2A obligations, and I think we covered most of this, but I'll just So the ongoing recruitment, again, you have to continue to accept applications up to 50% of the contract period, report any termination of workers within 2 business days. You have to notify your workers of the obligation for them to depart the U.S. at the end of their visa program. And whether you do that in writing or have something in writing in their language to explain that'll be required. You need to provide the work contract to each worker no later than the first workday, preferably before they enter the U.S. You can have the agent, or you can send them a copy of the ETA 790 job order application. You need to post and maintain Department of Labor worker protection posters at the work site in both English and Spanish. Adjustment of wages. So sometimes the minimum wage requirement under the adverse effect wage rate will change, and maybe it goes upward during the contract period. Well, your obligation is to increase that wage rate at the time that new wage rate is posted. It's sort of a thorny issue again, where sometimes the wage goes down. Does that mean you can lower their wage rate? And my recommendation is that you not do that. You only increase it upward because you've already advertised, you filed an application pledging to pay a certain wage rate. And by lowering that, you could run afoul of certain other DOL obligations. Travel reimbursement. So during the days that they're traveling to the U.S. after they get their visas at the consulate, you need to pay them $12.07 a day, up to $51 a day with receipts for meals and travel costs. Provide all tools, supplies, and equipment to the workers. And again, retain your H2A documentation and resumes and advertising for 3 years. Just some specific requirements in terms of payroll, which I see come up often in the context of H2A audits. The U.S. Department of Labor requires that you provide your workers with weekly pay statements or earnings records that include certain information. And so you have to have your pay records in a specific format, so worker's name and home address, number of hours offered each day, number of hours actually worked, rate of pay, total earnings per pay period, and the amount and reasons for any and all deductions taken from the earnings, as well as any bonuses or credits paid. So some challenges and strategies for H2A. The main challenge is that it's expensive. It can be costly for small farms who can sometimes be shut out of the H2A program. It doesn't directly include certain dairy farm workers, specifically people that do milking, because it does need to be tied to a certain season of the year, and cows are milked all year round. And there's no year-round coverage. You must hire any U.S. worker referred by the Department of Labor up to 50% of the contract period, even if that means laying off the H2A workers that you've already brought in. If you get qualified workers 2 months down the road, they would expect you to terminate the current H2A workers and send them home at your cost. You have to offer the same benefits to all U.S. workers performing the same H2A position. Some strategies. You can include multiple farm-owned properties in one application. So if you have different facilities, they can all be included, and you can have workers that rotate between these facilities. You can have a joint sponsorship by multiple farms or agricultural associations. You can basically group with neighboring farms or farms throughout the state and form and file under one application, as long as you agree on the same dates of need and the job duties are similar. That's a way to save on costs, because you're engaging in a cost-sharing program at that point. So that's a great way, and we're seeing more and more of that happening. You can file separate applications for crop workers, so general farm workers from March 1st, let's say, until November 30th. And then you can file a second application for a winter grounds maintenance worker from November 30th to March 1st. And what you can essentially do is transfer your H2A workers between these two applications without them having to go home. So if you do have a need for winter workers, and then you also have a need for crop workers, then you can have a worker feasibly in the U.S. for 3 years without going home between these two programs. After someone's been here for a full 3-year period, they need to go back home for 90 days to reset the clock, and they come back for another 3 years. So this is an option that I see a lot of farms doing now. The downside is the cost. You're paying for 2 programs a year and 2 rounds of advertising a year. but it is a way to get year-round coverage between the two programs. Dairy farms do qualify for H2A. Most dairy farms have crops, whether you're growing corn, hay, wheat. You can have workers filed under an H2A application for your crop-related work. A lot of times what we see is that, all the U.S. worker staff needs to be focused on milking duties, so that leaves a shortage in workers taking care of your crop work. So that's a justification to bring in H2A workers in the dairy context. All right, so I just want to briefly touch for a minute that you'll see I did include slides on the I-9, basic I-9 process, which we covered before. We're not going to go over that today, but I just want to mention that in connection with H2A enforcement under the new ICE age. Farms are targets, and they have been for a long time, but the new approach right now is going after the source or the magnet of illegal employment, which would be the employer. So they're going to focus on employers. What we see happening is as I-9 audits, it starts with that. So, as I mentioned in our last program, take a look at your I-9s to make sure they're in order, because, we're hearing all the time now that employers are getting visited by ICE in all sorts of industries, but farming has always been, unfortunately, one of the targets in this area. So it's important to be vigilant, given the new enforcement priority they just announced in January, that the new enforcement priority for ICE is to go after the employers. And we're seeing federal charges of harboring aliens, encouraging illegal employment against employers. So it's something to kind of keep in mind. If you have H2A programs, it's actually a great defense, because you're showing good faith compliance. Why would you spend thousands of dollars on a visa program if you're trying to have a pattern and practice of hiring illegal workers? So that's a great defense that you can raise. But again, just take a look at your I-9s, because that enforcement is really ramping up in all aspects. And I encourage you also to kind of look back at the last presentation on I-9s, just to refresh your memory on the basic requirements. And that's basically that's all I have for today. So I'll turn it back over to Farm Credit East.
Well, great, LJ. Excellent presentation. Covered a lot of ground and a real deep dive into H2A and all that's involved. So we have gotten a number of questions. We got 10 minutes here, so we'll certainly try to get through as many as we can. So one of the ones so you talked a little bit about New York State. Farm Credit East covers parts of 6 other states. Just wanted to check, I'm assuming many of the requirements that you talked about that would go through the state workforce agency, that would be applicable, I assume, that basically in another state where a producer might be seeking to bring in H2A workers.
Correct. It's the same process, same exact process. It's just the state aid. It's still the State Department of Labor. They just call themselves something different in the various states. But it will be the same exact process. It'll still be called the State Workforce Agency. It'll just be a different contact person in all of those states.
But like the requirements in terms of that initial state application would be, in a sense, those are laid out in the requirements of the program. It's just a different agency.
Exactly. So, and the only difference you're going to see will be at the state level, and the differences will be minor. It'll just be the State Department of Labor within that state, but they are required to follow the same exact procedure as well. The only distinctions could be certain housing requirements, because every state would have different housing requirements. Some of them would require a migrant labor camp permit, and that process may be different. But after you get through that first stage, everything else is identical.
Okay, and this may be one of the questions that came in may be related to that, because I'm assuming the adverse wage rate is different in some of the states. Someone asked if the rate was $12.83 or $12.93, and maybe that's a function of it just being a different state.
Yeah, so it's $12.83 for New York. Connecticut is $12.83. Rhode Island and Massachusetts are $12.83. New Jersey's $12.05, as is Delaware. So it does slightly vary. Vermont, but most of them in our region are $12.83 an hour.
Okay. So one of the things, and I think you alluded to this in your presentation, in terms of, obviously it's a pretty complex process. that there are, in a sense, agencies or services out there that will help people navigate it. Obviously, your firm provides certain kinds of services like that. Maybe you just talk a little bit about the role that those folks can play.
Yeah, so there are both non-attorney and attorney organizations that can assist in all stages of the process. So most times that would include them preparing the applications for you through the state, the U.S. Department of Labor and Immigration. And a lot of them also have relationships with recruiters, so they can even find workers. A lot of these agents have very large databases in various countries that have workers all set to go and lined up that they could, match with certain skill sets. So there's help available. It's, there are some employers that, do this on their own. It is a very complicated process. The one thing I caution about is compliance and complying with the legal requirements and the regulations, because some agencies may not be as focused on compliance-based issues. They're good at completing the application forms and doing the recruitment, but you want to make sure that whoever you're using is educating you on what the requirements are, because you will have an audit by the Department of Labor, and you just want to make sure that you're in full compliance.
Okay, great. So one of the questions came up related to, I think somewhere in your slides you'd had the renewal for up to 3 years. And you kind of mentioned that at the end. So when you say renewal, are you talking about a specific worker coming back for 3 different years? What is that particular account?
So they can basically, between 2 applications, somebody can extend. It's basically an extension of the visa they're on. So if they're here on a crop program for the season, we extend and amend to the winter program. So that can be done up to 3 years. So the worker will be physically in the U.S. for 3 years, then they have to go home, then they can come back and do it all over again.
Okay. And speaking of returning workers, when you talked about in the application how you kind of as a hedge, you will sometimes request unnamed workers just in case the workers you were intending to get, aren't available that particular year. But but if you are intending to bring back the same workforce, how does that work? Go ahead.
So there's no requirement that you list workers' names on the applications. You can go through each stage and just say, I want 10 unnamed workers without listing them, even though you know already who you're bringing in. But a lot of it is just more administrative, because if you do list the workers' names, then a lot of times you're going to have to submit documentation, their passports with the application, and it takes a long time to get the documents from the workers. So it's just administratively, it's easier just to file everything under unnamed workers. And then once you get an approval from U.S. Citizenship and Immigration, it's going to say 12 unnamed workers, and then that is presented to the U.S. consulate for each worker applying, and then they just get inserted in essentially into the program electronically, and then they'll get visas under that program. So it just makes things easier.
Okay. A couple questions came up. I noticed in one of your last slides you had that overtime does not apply. And so a couple different questions in that theme. Is there a maximum number of hours that an H2A worker can work? And if 40 hours per week are offered for a particular worker, or more than 40 hours per week, must that be offered to all the workers?
So there's, in terms of a max number of hours, there really isn't, but you have to offer the workers at least 1 day off for their Sabbath, whether that be a Saturday or Sunday. And you can't make the workers work more hours than you're listing in the advertising and in the application. As a precaution, what I generally do is if there's an employer that's having the workers work like 60 or 70 hours a week, that's a lot. So I just as a precaution, I have the workers sign a letter confirming that that's voluntary and that they choose to work that number of hours. And a lot of times they do, because they want to send money home to their family. So I would just have something in writing from them. You technically don't have to offer, well, you have to offer the same terms and conditions to U.S. workers that are performing the same job. So you should offer overtime because that can be viewed as a benefit to U.S. workers. But if you're classifying the U.S. workers differently, so maybe they're in a different role, there may be some overlap in duties, but if you can justify why a difference would be made in how you're treating them, then it would be okay. But the best practice would be to offer them the same overtime you're offering the H2A workers.
Okay, great. So so someone asked a question about meals being provided. Is that a requirement, or providing access for them for kitchen
you just
facilities?
have to you have to provide them either meals or kitchen facilities so that they can prepare their own meals, and that is all basically explained in the job order that you're filing with Department of Labor. You specify in there what you're providing, whether it's going to be the 3 meals a day or whether you're providing them with kitchen facilities, but it has to be one or the other.
What about breaks? How long, how often?
Well, what you would do is whatever you're offering to your other workers, you want to be consistent. The H2A regulations don't have anything specific with that. It's going to fall under general Fair Labor Standards Act and Department of Labor requirements for employment in general. There's nothing specific to H2A workers.
Okay. Someone asked what kind of time period you have after the employee arrives, that if it's not working out, when you can send them home without, in a sense, the 3/4 guarantee.
Well, you have to have, so if it's for cause, so say they come in and they're causing trouble in the workforce, they're starting fights, or they're just not performing, you've got to be careful. A lot of that will have to be outlined in your initial paperwork. So sometimes employers have work rules that they include, or housing rules that if they violate, it's in there that they can be terminated for cause. And if they're terminated for cause, then there can be some ability to not have to pay return transportation home. It really depends on the facts of the case. But all of that would have to be laid out initially, what the employer defines as cause or just cause, so that everybody's clear from the beginning what the requirements are.
Okay. You mentioned in terms of making sure you get employee consent for withholding. Someone asked if a W-4 in Spanish form, I'm presuming here that signed by the employee, would satisfy the requirement that they have authorized that.
Yes, it would. The fact that they sign that W-4, and especially if it's in their home language and they understand what they signed, then that would be sufficient.
Someone asked a question about 401ks. I'm presuming here that if an employer is offering that to their other employees, would H2A's workers be required to be included as well?
If they qualify for it, so there may be rules where seasonal workers are excluded or they don't have to be covered, but again, nothing specific to H2A that would fall under the 401k program rules itself. But on a general level, I guess any benefit should be offered to both if they're performing the same job.
Okay. And I know we're right at the top of the hour here. I actually have one more question, and I think then we'll wrap up. Question came in: if you hire domestic workers that apply, and obviously because you're required to keep recruiting for them, as you pointed out, if you get people who want the job, I think it's a question of, do you have to give up the H2A worker for each qualified applicant that you do get?
As long as you hire that U.S. worker, then you don't have to get rid of one of the H2A workers. It's only the case where you don't hire the H2A worker, where or to hire the U.S. worker, where the H2A worker would have to be displaced. But if they want to hire, the U.S. worker, maybe offer them a different position. Maybe it's a higher level position or doing something different, and they accept it. Then you can keep employing your H2A workers as long as you're not displacing a U.S. worker.
Okay, great. Well, great, LJ. Excellent information. Thank you for the presentation and the discussion. Thank everyone for joining us. As we pointed out, we will be posting this to our website at farmcrediteast.com/webinars. You'll note on the screen that we do have an upcoming webinar in a few weeks on March 13th, where we're going to have a green industry outlook, so turf grass, nursery, greenhouse. So if those of you involved in those industries might want to tune in for that. So again, appreciate everyone joining us today, and hope everyone has a great afternoon and a great weekend. Thanks.